Okay, and I understand that you have a motion for continuance that now we've confirmed is unopposed. Is that correct?
That is my understanding, Judge. Mr. Morgan's on, and he can confirm his position, but I believe it is unopposed.
It is unopposed on the motion to continue this, Your Honor.
Okay, when would you like to reset the trial setting?
Judge, I think we had asked for a setting about in the April timeframe. Whatever you've got on the docket, it's a non-jury case. Let's see what we said in the motion here. We had asked for the first available setting on or after April the 18th. So whatever is convenient for the court, my calendar's open.
Let me just go to that date. April 19th is not a bad week, at least not right now. We have a special setting April 26th, but we only have 5 other cases set. So it's as good as any. May 3rd, I would probably avoid May 17th, but May 3rd is okay. May 10th is, none of these are great. May 10th is okay. April 19th is okay. And then April 26th, we have a special setting, but only 5 of the cases set.
Judge, I'm good. Any of those dates on my calendar, Mr. Morgan is free to pick.
I'm going to be free, but I'm scheduled for back surgery or conditions in Rockwall at the Texas Back Institute. But I sure to gosh hope I'm way through with that way before April.
When is your surgery scheduled?
Well, it's not scheduled now. We're still waiting on the Texas Back Institute in Rockwall to give us a confirmation because the surgery is up and down depending on how I can function with a new prescription they want to try.
So do you feel comfortable with April 19th, or would you rather?
I feel fairly comfortable. Surely that's long enough, far enough away. That's almost 6 months that I ought to be able to drive and function then.
Judge,
Make my wife drive and nothing else.
If there's an issue with Mr. Morgan's health condition as the trial date approaches, we're not gonna try to force the issue. If he's got a back problem, we'll get back with you and update the court and ask for some relief for him.
Okay. So April 19th works for everybody.
Good for plaintiffs.
As far as I know, Judge, yes. I represent the defendant.
Okay. I'm sorry, and I think you told me the trial setting. What is the trial setting on this again? I'm sorry, what is the cause number on this?
Cause number DC 2100738.
And that's Mid-Continent Geological versus McCutcheon's Petroleum Corporation.
That's correct,
Yes, Your Honor.
All right, we agreed to April 19th, and it's a non-jury at this point. Okay. All righty. We will go ahead, and is Crystal Griffin on this case with you guys?
No, sir. It's just me and Mr. Morgan.
Okay. She keeps on trying to sign in, and I don't know what case she's here for. So, all right, I will let Rhonda know. We're going to go ahead and reset this. Have you guys picked a mediator for this case?
Judge, you appointed, I think it's Tamar Meeks, and she circulated a request for dates, and we'll, as soon as Mr. Morgan gets his back surgery schedule figured out, we'll get with Ms. Meeks and get some on the calendar.
Sounds good. All right, you guys are excused. Mr. Morgan, I hope you feel better.
I do too. Thank you, sir.
Thank you, Judge.
Okay. All right. Is everyone here on the status conference? Mr. Curry?
Yes, I'm sorry, I was trying to unmute. Yes, and we filed a motion on Friday as well, or I'm sorry, yesterday night, seeking to a contempt motion, 1, and then B, to modify the TRO to extend it to 1 additional ground in light of the defendant's response to the motion, for lack of a better word, or a better story. And we can, to be honest with you, I'm not really seeking to put anybody in jail. I want compliance. And I think we do need the broader ground given the lack of compliance.
Your Honor, if I may, Crystal Griffin is on here because she's licensed in Texas and I'm not, and I still haven't had a chance to pro hoc in. But we just received their filed motion last night, as Mr. Curry represented, and we are prepared to comply with the terms that he's asked the court to enforce. And if you're not going to, if you're going to hear his motion, we'd ask for a little additional time so that we could respond properly.
And Mr. Curry, if you want to do a contempt motion, I'm not going to do it like this. It'd have to be in person. We need to give notice and all that kind of stuff. So
I understand that, but I would like to the piece of the motion, the alternative relief, which was to expand the TRO. What we've learned is that censure order basically required three things: is access to accounts. That's not been given. Particularly there was $5 million that had been transferred out of the LLC, and that was transferred into an account for one of the members and out of the LLC and into the members only account. And we want the additional ground of relief that we're seeking is for that money to be transferred back into a LLC account, as opposed to just one member, the minority member, controlling nearly $6 million in LLC funds outside of the LLC. We also learned that they were continuing to make transfers despite your order, which required that my client, the majority LLC member, approve any transfer. And in light of those two things that we've learned since our original TRO, we're asking the TRO to be expanded to require that those funds be brought back into the LLC account.
Your Honor, I'm prepared to respond to those, but I understood the court to say that we were not going to be hearing this right now.
Well, I just want to find out what's going on. Is this true, what he's saying, not true, or what is your understanding?
So my understanding, Your Honor, is first of all, that there was, both parties have mistrusted each other for a few weeks now. And Mr. Curry's client first removed funds from the account. Then my client, as a precautionary measure, as the operator of the company, removed funds from the account. And this morning, before today's hearing, I let Mr. Curry know that we are prepared to provide him and his client with visibility access to where those $5 million are. But at this point, all that money is really spoken for. My client provides critical testing for COVID right now. And my two clients are individuals that are part of the company. They know how to operate the company, and Mr. Curry's client doesn't. So they're just every day trying to keep the company alive despite this chaos that we're experiencing with this legal dispute. So the transfers he's talking about, it's not like we're transferring money around. It's just day-to-day operations. There's millions of dollars that are being spent to purchase reagents and supplies and pay vendors. And it's not what Mr. Curry is making it seem like. And furthermore, he made it sound like there's no access being given according to the TRO. We provided access to the bank accounts and to the QuickBooks, which is what they asked for.
Mr. Curry is saying that there was $5 million put from the LLC account into a minority member's, I guess, independent bank account. Is that what you're saying, Mr. Curry?
That is accurate. $6 million that I'm aware of.
That was before the litigation was filed. Yes.
And we only learned about that when we got access to the where that money went. I had presumed it had gone in when we were before you last week. I had presumed that money had gone into some sort of marquee account. I didn't have any clue that it had been transferred into a single member's account. And when I learned that, I immediately asked that it be put into a marquee's account. And then I also learned that the accounts where it went to, that we weren't given access to know what's gone. Of that 6 million, I'm now told that $1 million's gone. And I have no clue where it went because I haven't been getting access to that account. We asked that the money be put back into the Marquis PNC account, and that any expenses be approved as we set forth in the order would be by my client. My client's prepared to say, if there's a legitimate business expense that needs to be paid, for a check to be written or a transfer to be made. But just for one side to not like what this court has put in place as a means to get through this until December isn't acceptable.
Well, he said it was done before the order was in place.
Yeah, but he hasn't given us access to the accounts, and those monies ought to be returned to the LLC account, the account for the entity that owns the money. That's appropriate TRO relief. It's a fact we didn't know when we were in here before. It's before you in a verified motion for those funds to come back into the LLC account at PNC Bank.
Mr. King?
Your Honor, it's a problem just merely because of mistrust, as the court can understand. I mean, so what they're wanting is they're wanting to have control over those funds. So that as the majority partner, if they start doing something with those funds, such as paying themselves or paying creditors that they believe need to be paid before the way the normal operation of the company is being paid, then it's going to mess up the company's ability to pay its debts as they come due, and its vendors and obligations after they've incurred a bunch of expenses during the COVID spike.
What right does your client as a minority member have to do this? It doesn't seem like they usually would.
Well, the usually thing is a good point. And I don't, generally the idea of saying, well, this is how we've always done it is not the best explanation, but that really is exactly what's been happening. Is Mr. Curry's client he represents the investors that have put up the money. They don't know anything about the day-to-day operations of this company. And my clients are the ones that have been trusted to make sure that this company continues to enjoy the success that it's enjoyed. And over the recent months, that it really has started to be very successful because of the critical PCR testing that they're doing. So my clients are the ones that are interfacing with vendors, interfacing with customers, and working with employees to make sure this company is operating. And now his clients are saying, no, we want to be a part of every single decision all day, every day. And well, all we're trying to do is keep the company operating so we can get to mediation. And we're not hiding anything. He's got access to visibility of everything, every transaction that we're doing. And as I said earlier, this morning we're able to provide access to the 5 million plus that he's talking about. And there's nothing being hidden. There's nothing being taken. It's merely just my client.
Mr. Curry says there is something being hidden, correct?
Yeah. A, I haven't had access to that account. B, I know at least $1 million of that money has gone somewhere. And there's never been a precedent where one of the members takes all the money of the business out of an LLC account and places it in an account that they control. I mean, my client is the majority vote and has 60% and the majority vote in case of any tiebreakers. I mean, obviously has fiduciary duties in terms of, just can't willy-nilly take money out of the account. But, for one side, if you listen to the story that's being told is we don't trust them and we don't have the vote to overrule their decision-making when they have the majority vote. So we're going to take it over to our house and keep it there where they can't exercise their LLC authority. That's exactly what a TRO is intended to resolve in circumstances like this. The money needs to be back into an LLC.
So at this point, I'm going to expand the TRO to require that money to be returned. So if you could, Mr. Curry submitted a proposed order to Mr. King on that. The bond is going to need to be increased significantly. What is the current bond on this?
$500.
It's going to need to be, I would say,
5,000 at the max.
I don't know about that. Mr. King, what do you propose?
I mean, I'll defer to the court on that.
I'm not advocating for your client, so this is that if you're concerned that they're going to take the money and improperly, then you need to have a big bond, but I'm not representing your client, so it's your call.
Well, I mean, obviously, if it's a $5 million risk for the business, I mean, and my clients really are representing, they're not trying to take this money for themselves. This money is being used for Marquee Labs LLC, which is the company that Mr. Curry's clients and my clients are trying to work together to continue to develop. But I mean, $1 million bond would be sufficient for us.
Your Honor, yeah, I mean, that's ludicrous to post a $5 million bond when there's been no evidence of any type of wrongful act by my client to simply move the money back into the account to where it should be. My client has the majority vote. If it voted to spend the money one way and they didn't want to spend it that way, as long as it was a legitimate business expense, he would have every right to make that vote. And so, I mean, the 5,000 is an appropriate amount, and unless and until there's any type of
Mr. King, you said your clients don't trust Mr. Curry's clients. Why not?
Well, the thing that really kicked off this entire litigation, and to be clear, it first started in Oklahoma, and then we had a TRO hearing scheduled for last Monday here in Oklahoma City, and we ended up moving it. There's jurisdictional provisions in the operating agreement that say that these proceedings need to be had in Texas. So, but the reason why that got filed is because Mr. Curry's client took $76,000 out of the operating account and left Marquee in the lurch with, having my clients having to put personal credit cards on file to pay for the operations. And so in order to try to avoid being stuck like that again, my clients got nervous and decided that they needed to protect this because they have,
So I'm unclear if they took $76,000 out and your clients had to use their personal credit cards, but they took $5 million out. Why didn't they use the $5 million?
It's confusing. There's numerous accounts, Your Honor, that this company has, and there's an operating account, which is the one that Mr. Curry's client removed the funds from, and then my clients have a different account that is really just kind of being held. The majority of that $5 million is spoken for. As I said, I mean, there's been a major expenditure over the last 30 plus days because of the Delta variant spike and all of the different equipment and supplies my clients have had to purchase. So it's not like that $5 million is just profit that is just sitting there waiting to be distributed among the owners. So my clients are just being cautious. They want to make sure that they have the funds available to take care of the obligations of the company. And they're just nervous that Mr. Curry's client is going to say, no, we think that the money needs to be used this way. And they don't know how to.
They are the majority shareholder, right?
Yes, but they do not know how to operate the company. And I think they would admit that.
Well, a couple observations first to that, Your Honor, is that the money that all of this was explained in our TRO. The $50,000 was taken out after they locked us out of the bank accounts. And when my client went and hired a lawyer, it was a different lawyer than me, and placed a $50,000 retainer, which will probably be transferred to me to specifically get access to these accounts. The other money that was taken out is specifically provided in the LLC agreement.
Mr. Curry, I guess I'm not clear. Maybe I just don't know. So how were they able to lock your clients out of the accounts if you're the majority shareholder? Didn't you have joint check writing on this?
We had access, but we did not have access to a joint check. We've been trying to get access to that account, the Chase Bank account, and we did not have the signature authority on that account. And that's how they were able to transfer and deny our access.
You're the majority shareholder. You don't have.
It was
before your time, right? It was before your time.
You can imagine that my client's not very happy about that. And just in terms of what I'm hearing Mr. King says is actually much more disturbing than what I even learned even before today, in the sense that this $5 million is spoken for in the terms of major expenditures being made, none of which have been approved by my client, the majority LLC member. And so, I mean, it just, this story gets worse as we learn more about this, because there was a dispute on how to use this money when it came in the company, and it appears that the defendants have chosen just to go and make commitments without the majority's consent on capital expenses and otherwise. And it's just, $5,000, the more you hear is probably too much. And my client recognizes the fiduciary duties that he has and making in the court, moving that back into an account that he has signatory authority with, jointly with the defendants.
I'm going to set the bond at 50,000. I'm going to recommend that you guys consider filing either a receiver action or maybe an auditor to try to figure all these issues out, because it sounds like there's a lot of different accounts and all that kind of stuff that might be helpful to the court and to the plaintiffs to figure out what exactly is going on here with all these different accounts. But I'm not going to do that sua sponte. But if you guys, I can urge you to consider one of the two of those options, or maybe a special master. I don't know the special master necessarily makes sense, but an auditor, I think, or a receiver might. And on the contempt, I'll go ahead, and Mr. Curry, if you could prepare the proposed order, share it with Mr. King and Ms. Griffin, and then get me a copy of it. Make sure you email Rhonda as well as e-filing it, and put down that it's an amended TRO dated on today. So at the beginning, say on November 15th, the court heard the following, blah, blah, blah. And
the issue on scheduling, we're not terribly apart on that. At least on an initial basis, I think we're all in agreement the three principles need to be deposed. I think interrogatories, requests for admissions, and disclosures are agreed to. I think he said 8 interrogatories. That's fine with us. 8 requests for admissions. That's fine. And then the disclosure responses. I think that the disagreement is that I'd like 12 requests for production. I've sent drafts of those, I think 9 or 10 of them on Friday to Mr. King. And then timing is that he wants to do mediation first. I've got to put him under oath to figure out, what these commitments are, whether they were done with approval, and what led to these commitments. The more I've heard today, the more I know I need a deposition of the defendants before I can meaningfully mediate. What I would suggest is that we take a 3-hour deposition of each of the individuals, 3 hours being on the record time, and that would reserve 3 hours for later on if the case were to continue after mediation and after the injunction hearing, and that would, the depositions would be scheduled either next week or a little bit after the document.
Did you guys agree on a date for the temporary injunction?
We did. It's in December sometime.
Mr. King, what day is it?
The 10th, I believe.
10th, okay. Wait, let me see. Is that one of the dates I gave you?
Yes.
Yes, Your Honor.
Okay.
And that would give us plenty of time to do this.
Your Honor, if I may, I mean, the last Wednesday when we had a hearing before, today was intended to be to discuss the scheduling, and I realized Mr. Curry filed the emergency motion yesterday, but you also ordered us to attend mediation. And so soon after Wednesday's conference, we were working on trying to schedule mediation for tomorrow with Judge Harlan in Dallas, and we had agreed upon using him. And then, more mistrust arose, and here we are. But, it is crippling to this company. It's a fragile operation, and the parties are ready, as far as I can tell, to try to work together to see the company continue to be successful. But, this kind of litigation and requiring 3-hour depositions of all three of the principals between now and soon after Thanksgiving is really going to hinder the company's ability to operate. All we would like to do is try to get to mediation as soon as possible to try to work all this out. I mean, I think
Mr. King, do you feel it would be successful though if they don't know what your clients have done?
I mean, I don't think that we have to have under oath depositions to get to the point of where we can get to the mediation table. Yes, I asked my client that this morning, Your Honor, because after seeing Mr. Curry's motion and the frustrations that everybody's feeling, I said, do you feel still at this point that we can work this out? And he said, yes, I think, and my client is the primary officer. I think he's reluctant.
So this is what we're going to do then. We're going to have the primary officer, the one you just said, be deposed for 3 hours. Then we're going to do mediation. Then we're going to do the rest of the discovery. So
I'm going to need documents for his deposition though, Your Honor. I would do this. I would agree to mediate this week if you lowered the bond to 5,000 so that we could get that money into the account, into the joint account. And so there's not that leverage where the money is being held hostage. And then do the document request going out simultaneously and deposition scheduled the week after Thanksgiving.
Wait. So you're agreeable to what? Reduce the bond to 5,000 if what again?
If we will mediate this week, if the bond is reduced to 5,000 and the document requests go out today and they're responded to next week and with depositions the following week.
Mr. King?
That seemed, I mean, the bond amount is low, I think, but I mean, especially given the amount of money at risk here. But as I said, I mean, I stand by the fact that my clients have been asking since the moment this litigation got filed if we can get it resolved.
So you agree? So you agree to his proposal?
Yes.
Okay. All right. Then let's lower the bond to 5,000. Mediation will occur this week. Prepare an order on both of these things on the expedited discovery. The mediation is going to be with Judge Harlan. Is that right?
Judge Martin. If we, I can't remember what days he has available later in the week, but we'll get somebody scheduled this week. I mean, there's the great thing about being a Dallas County lawyer is it's unlike a lot of venues. I've got a case in Portland. We can't find a mediator. There's fortunately a lot of good mediators in Dallas. So if he's not available on one of the dates later in the week, we'll find somebody else.
All right. So mediation will occur this week with Judge Martin or somebody else. And get me an order on all of this, Mr. Curry. Share it with Mr. King, and you guys are excused. Thank you so much.
Thank you.
All right, let's now deal with.
Good to see you, Mr. Reese.
Nice to see you, Curry. Hope you're doing well.
I'm alive.
Take care.
Sorry, Your Honor. I just haven't seen Mr. Reese. We were litigating the day before the pandemic began.
Oh my gosh.
And wondering exactly what was going to happen. I certainly didn't predict that we would still be struggling through this.
Yeah, neither did I. Neither did I.
I thought maybe April 15th we'd be back in the office.
Yeah, that did not turn out to be. Good to see you, Mr. Curry.
Thank you.
Tony, let's go on the record on cause number DC 21-10229, Dreesy versus Ojala Partners LP. Counsel, make your appearances.
Gregory Cliff for the plaintiffs.
Allison Cook here with my colleagues Joel Reese and Jamison Joyner for defendant Ojala Partners LP.
Okay, let's proceed.
Thank you, Your Honor. Is it okay if Mr. Joyner shares his screen with a short PowerPoint as I go through my presentation?
Okay, yeah, give me 1 second. Go ahead.
Thank you, Your Honor. Thank you, Jamison. And Your Honor, the court should grant this motion because the communications at issue here are largely communications with government officials that deal with a keystone matter of public concern, that is affordable public housing. And plaintiffs have not met their burden under the TCPA to prove a prima facie case of each element of their causes of action. Defendant Ohala develops affordable public housing largely through partnership with local housing authorities and local governments. And those partnerships are awarded through a public bidding process. Plaintiff Mr. Dreesy used to work with Ohala. He left and he now works for a competitor. And based on information and belief, Mr. Dreesy has stolen Ohala's confidential information and is using it to improperly and unfairly compete for government housing projects. When Ohala began to investigate Mr. Dreesy's misconduct, Dreesy sued for defamation, business disparagement, and tortious interference. And Your Honor, those three claims are subject to the TCPA because they are directly in response to Ohala's communications regarding the fairness of the public bidding process for affordable housing. If Mr. Joyner will go to the next slide, I can show the court. This is one of the 5 communications plaintiffs are complaining about. It's an email from Mr. Vrujink at Ohala to the Houston Housing Authority. And it is just representative of the communications explaining that Ohala to Houston Housing Authority has a strong reason to believe that a former employee took confidential information and is using those materials to compete with Ohala in the public bidding process. Because the TCPA applies, the claims at issue should be dismissed because plaintiffs have not made a prima facie case, namely for 2 reasons. First, they have not offered any evidence whatsoever of actual or economic damages, which are required for claims for business disparagement and tortious interference. And number 2, they have not shown that the statements are false by clear and specific evidence, as is their burden under the statute. And alternatively, Your Honor, the affidavit of Matt Vrujink, which was attached to defendant's motion, establishes the affirmative defenses of substantial truth and privilege by a preponderance of the evidence. And therefore, on that alternative basis, the causes of action should be dismissed. And Mr. Joyner, thank you, Mr. Joyner. As I touched on earlier, these communications involve a matter of public concern and are subject to the TCPA because they center around the fairness and integrity of the public bidding process for affordable housing developments, which is a matter of public concern. Some 2 courts in somewhat similar circumstances, both out of Fort Worth 2020 opinions, have found in the Wynn case, the court held that communications were subject to the TCPA when they were on an issue related to the government and its public bidding process. And similarly, in PNC, the Fort Worth Court of Appeals held that allegations fell under the TCPA when they concerned a public redevelopment project.
But were both of these opinions interpreting the new version of the TCPA or the old version of the TCPA?
They were applying the old version, but we would maintain that the amendments don't affect the analysis in that instance. And the Westlaw sites are there. If the court wants to look at the opinions, I'm happy to email them after the hearing. If the court just will let me know, and I'm happy to do that.
What I'd actually like you guys to do is submit, if you could get it to me by Thursday, a notebook. I've read all the briefing, but there's quite a few cases to go through. A joint notebook that has the plaintiff's, the motion, the response, the reply, and all the key cases highlighted and included within the binder. If you could get that to me by Thursday, that would be great.
Sure, I'm just making a note of that really quickly. We'll coordinate with plaintiff's counsel on that and get that to you by Thursday. Moving past that, Your Honor, in plaintiff's response they make the argument that their causes of action for defamation, business disparagement, and tortious interference are exempt from the TCPA under section 27.010 subsection A5A. Both the plain language of the statute and relevant case law mandate that exemption simply doesn't apply to those causes of action. As the court's aware, and the text is on the slide right here, the exemption they're seeking to apply only applies to legal actions arising from employee-employer relationship that seeks recovery for misappropriation of trade secrets or corporate opportunities. Plaintiffs are seeking recovery for defamation and business disparagement. They aren't seeking recovery for misappropriation of trade secrets. And based on their response, they're attempting to apply this exemption to the lawsuit as a whole because Ohala does have counterclaims for misappropriation of trade secrets. But as plaintiffs pointed out in their briefing, courts have considered that argument and have disagreed with that analysis and have explained that the exemptions are intended to apply on a cause of action by cause of action basis. It's not meant to apply just because there's one counterclaim for misappropriation of trade secrets. That doesn't mean that the entire lawsuit is exempt from the TCPA under this exemption. And
Aren't your causes of action essentially for misappropriation of corporate opportunities?
Well, tortious interference and misappropriation of corporate opportunities, I think, are different causes of action.
Are there any cases that interpret what a misappropriate, because that's not a cause of action, misappropriation of that I'm aware of corporate opportunities. What does that mean exactly under the case laws? Are there any cases that interpret that?
I'm happy to look into that, Your Honor, and I can include it in the Thursday binder with the cases and maybe some supplemental briefing.
Or let me just ask this: does the respondent agree that misappropriation of corporate opportunities is not what the plaintiffs are seeking in this case?
We are not seeking that specific cause. If there's a specific cause of action, which of course, like you mentioned, the statute does not delineate specific causes of action. It's more concepts, misappropriation, trade secrets, corporate opportunities. And obviously you've read the briefing, but the underlying of all of this is misappropriation.
So you believe the exemption applies to misappropriation of corporate opportunities?
I believe nobody's made a decision yet, but a plain reading of the statute should, especially in these circumstances, because nothing else is at issue except for the misappropriation allegations on both sides. And it seems, considering that the whole idea was to get to a point where this statute wasn't being used to overwhelm the courts and the appellate courts on these types of claims, it falls right into the purpose of it, that where our defamation claim relies on the claim that we misappropriated, or they can just go out and say whatever they want, but they're protected. So there's a quirk in there, obviously, and we think that this applies potentially. Again, we don't have any Supreme Court or Dallas case law on it. And I did lay out, I believe, both of these cases in my response to let the court know the other cases have addressed it.
Okay.
They did, Your Honor. But obviously, defendant disagrees with that analysis, as the plain language of the statute applies to legal actions that seek recovery for misappropriation. They're seeking recovery for defamation and tortious interference and business disparagement. And as plaintiff's counsel points out, there is case law where courts have said you go on a cause of action by cause of action basis. You don't interpret legal action in the broad sense of the entire case is exempt, and each discrete cause of action is exempt because one of the many falls under one of the exemptions.
Okay. Go ahead.
Jameson, go ahead to the next slide.
Yes, please.
Thank you. And Your Honor, since defendants established that these causes of action fall within the gambit of the TCPA, was plaintiff's burden to prove by clear and specific evidence a prima facie case for each element of each cause of action. are two glaring reasons why they haven't done so. The first of them being damages. Mr. Dreese's affidavit includes some testimony as to mental anguish and stress, but nowhere do they offer any evidence of actual special economic damages, and which are required to prove claims for tortious interference and business disparagement. So those two claims, just based on the lack of damages, should be dismissed. And with respect to falsity, that would apply to the business disparagement and defamation claims, which both require that the statement in question is false. And Mr. Dreese's affidavit does not actually counter. It doesn't argue that Mr. Dreese didn't take information, that Mr. Dreese isn't using information. The closest that they get is to say that Mr. Dreese didn't take what he understood to be confidential information. And that's far from the clear and specific evidence required to refute the statement or statements that Ohala has reason to believe he took their confidential information. That just doesn't rise to the level necessary to prove a prima facie case. Jameson, you can go to the next slide. And alternatively, Your Honor, if the court does find that they've proved a prima facie case for their causes of action, Ohala's established affirmative defenses by a preponderance of the evidence to these statements. The first being substantial truth, and that's set forth in Mr. Vujink's affidavit in paragraph 11. Being the first one, he's also established privilege, justification, and privilege to make these communications. All that Ohala was doing in making these communications was preserving its right to a fair bidding process. And finally, our motion and our reply show that at least one of the communications is covered by judicial privilege. And so for those reasons, Ohala would ask that the court grant its motion in its entirety and award attorney's fees under the statute, which Ohala will provide should the court order at whatever date the court desires.
Response?
Thank you, Your Honor. Obviously, since it's clear that you've read everything, I'll be brief and hit the highlights on this. As you know, Mr. Dreese was a former employee of Ohala. He operated for approximately 15 months until out of the blue, we started receiving communications regarding alleged misappropriation by Mr. Dreese. As we know from the briefing I provided, I firmly believe that this is strictly a business dispute. We're in an issue where they are claiming that Mr. Dreese misappropriated information from it. Now, what that specific information is, we have no idea. We have no idea whether it deals with anything regarding the public and regarding any of these contracts. There's just these misappropriation allegations that are thrown around out there. And as we know from counsel's comment earlier, it's on information and belief at best that he stole anything. However, we have clear allegations that my client's a thief. And so this is problematic, obviously. We know that from the letters that were provided that the real reason of this is to avoid paying him compensation that he's due underneath his agreement with the company. They make that very clear. You stole from us, so therefore you no longer get access to this money. We're not going to pay you. In fact, as we know from the email that we provided and excerpted in the brief, that they're very clear. We're going to fight you to the death on this, plain and simple. I think based on the facts that we've been able to develop so far and be able to file this lawsuit, that we have plenty of evidence that this is clearly a business dispute at this point between an employer and a former employee. We have provided you the letters and affidavits from our exhibits. And then
Mr. Cliff, can you address the two cases that discuss, because I mean, the first issue is this even a matter of public concern? There are two cases, I guess, that have been cited. Can you just kind of lay those out, and how are they different or similar, or analyze them in relation to our case?
I took a look at those, and I took a look at it again this morning to see if there was anything out there citing those. Again, these deal with the prior statute. I'm not, admittedly to the court, I'm not seeing a whole lot of difference between the prior statute for what they're relying on, because the public concern issue. I get back to the issue that I don't believe this misappropriation between these are public concern. The other cases are kind of different in the sense that these are the company who sued the employee underneath the old statute, claiming that you've misappropriated, you've used confidential information, you've done that in the purpose of getting into these public contracts. I think this is more narrow because it doesn't really get so far as to get into these issues of the public contracts. It's really just a dispute between the employer and employee. There is a significant amount of evidence provided under both of these cases of all the activities that were alleged as to how that impacted the public and the public's awarding of those contracts and the use of that public money. Here, we don't even have any issues with respect to whether any of these the interference done by them resulted in any sort of contracts or agreements, or they even got to the finish line on those. So it's not as on point as the initial dispute that we're having. That is, we've got Ohala through its principles running around telling everybody that my client is a thief. So I think they're markedly different in the way they're postured.
Do you want to say
With
anything else?
respect to
Go ahead, Mr. Cliff.
Sorry. And with respect to the public, with respect to whether this applies underneath the TCPA, again, we need to look at the content, the form, and the context of these, as I pointed out. I think the context is very clear. This is an opportunity for Ohala to try to interfere with Mr. Dreese's new employment and potential work that his company, Lavoro, or who he works for, is able to obtain contracts from. So we don't believe it necessarily applies. We talked a little bit about the exemption. And like I laid out in the brief, I did not find anything specific on this. There are a couple cases that say you do it by a cause of action by cause of action, and they interpret misappropriation of trade secrets and the business opportunities to be causes of action. I don't see that reading in this particular statute. I think this is a legal action. I think it's all premised on the misappropriation. Moreover, we don't really know what the misappropriation is, so how that affects the public anyway. So the whole purpose, again, of the amendments, in large part, was to get this narrowed down so that we're not arguing about this misappropriation issues in the employer-employee context. So I think the exemption could apply. We don't have any definitive case law on that. I think it's worth a consideration both for the exemption itself, but to also look at whether this really touches on something that's a matter of public concern, since the legislature and the courts had such a strong focus on the issue of misappropriation being cause of action and related actions being abused through this TCPA process. We then go into the actual causes of action. With respect to the defamation, I think we're dead on with the defamation. We've established all of the elements. We've laid it out in the briefing. This is a theft allegation. We have damages simply because we have nominal damages, as well as the mental anguish and despair that this has caused. So that has been met without a problem. With respect to the business disparagement and tortious interference, I think I was clear in my briefing that we've met all the other elements, but I don't see where we have those specific damages at this time. Admittedly, we think we would end up getting those damages as we went through the course of this litigation, and we'd be able to establish those. But at this time, underneath this accelerated proceeding, since we don't think TCPA applies, we don't get to those, and I do not have specific evidence on those.
So if I find the CPA does apply, then I should dismiss those causes of action.
Then I've got a problem with those two causes of action, no doubt about it. So, and I lay that out in the brief, Your Honor. I was very clear about that, I think. Not here to waste your time by any means. So, insofar as we start getting into the justification, the other defenses, we're getting into a matter of you can't simply do something illegal and hide behind these. The fact is that we're in a situation where they're out there coming after my guy, claiming he's a thief, both through communications with Trinsic's attorney, and Trinsic's his new employer. And so they're trying to interrupt that relationship. They're talking about comments being made to us and copying Trinsic, once again, trying to interfere with Trinsic, but then claiming that there's contracts out there, that he's violating things that simply do not exist. Then on top of that, they're going after the entities, the city of Houston, city of Dallas, or Houston Housing Authority, trying to interfere and disrupt that, claiming theft and things. And so we're getting beyond what should be considered anything privileged or justified. We're getting into a situation where this is tortious conduct being conducted against my client for which he should be able to seek the damages that he deserves. I think that covers it all, Your Honor.
Thank you, Mr. Clip. This is what I'm going to do. I wanted you guys to get me the briefing with the key cases highlighted by Thursday. I'm going to try to make a decision within the next 3 weeks. Any deadlines that I need to know about to make this sooner, or does 3 weeks work okay?
I'm not aware of any coming up yet because everything's been put on hold basically so far.
And let me ask this. So this case is pretty new. Is it set for trial?
Don't recall right off the top of my head, Your Honor.
Let me see. It is not set for trial. Is this a level 1, level 2, level 3 case? Do y'all know?
I believe we filed under, well, Rogge filed it, so I'm sure he requested level 3, but I know it's less than $1 million. Let me check real fast.
I'm looking at the amended petition right now. Let me see.
We initially requested level 2. I don't have the amended petition in front of me right this second.
Yeah, it's level 2. Okay, so when do y'all want to set this for trial? Needs to be sometime next year. Probably sometime late summer, early fall, or mid fall.
It's going to need to be early fall for me, Your Honor, considering as you can imagine, we're trying to get everything shoehorned in, and that's when it starts opening up a little bit where I have possibilities. May we provide you some options when we send down the notebooks on Thursday?
I'm just going to set it. It's a level 2, so I just set it. But if you wanted any input, you can have it now.
Your Honor, this is Jamison Joyner for Ahala. I would note that in our counterclaim, we requested a level 3 discovery plan.
Okay, I think you're going to need to, yeah, the plaintiff's request controls unless there's a change. But I mean, I guess the question from y'all is I can just set it, or if you guys want to do a scheduling conference and talk about an agreed scheduling order, if everyone wants to agree to a level 3, you can. I don't know, Ms. Cook or Mr. Reese, if you have an opinion on this.
I do not, Your Honor.
Nor do I, Your Honor.
So do you guys want to agree to a level 3 or?
I suggest we agree to level 3 to avoid, just get it all nailed down and be done with it.
That's fine.
Yeah, given that we asked for level 3 in our counterclaim, I think we're probably amenable to that.
Okay. Well, I'm sorry, did both sides agree? Both sides have agreed, right?
Yes, Your Honor.
Okay. So level 3, so what we're going to do is set a scheduling conference for you guys, so you can either get your agreed scheduling order in, or we can meet with you. And you can't move this, so make sure it's a day you're available. I could set you on December 6th or 13th. Which day would you prefer? And again, you don't have to show up if you give me an agreed order. It's either going to be December 6th or 13th at 10 o'clock.
Jameson, I'm going to defer to you on what your calendar looks like here.
I can do either.
December 6th is probably preferable. My wife's due date is the week of the 13th, so I'll try to build in.
Let's
Probably
do the
preferable.
6th. Yeah, I think it's definitely preferable. So
Yeah.
December 6th. And then who do you guys want to use as a mediator? Because I'm going to either.
Can we just plug that in there? I'd say, I mean, the usual suspects, John Shipp or Chris Nolan, have done me a lot of good lately.
Nolan's good, but Nolan, he's really hard to get scheduled now. I think he's scheduling way out in advance. But yeah, we would agree with that. Either one of those.
Which one? So Chris Nolan or Shipp? I don't care. Which
I'm
one.
thinking for what I'm learning from these personalities that Nolan may be the best for this one.
Works for us.
Okay, just let me write a quick note on this. All right, so we're going to do Chris Nolan is the mediator. Scheduling conference will be December 6th at 10 o'clock. And then you guys just And again, you don't have to show if you give me an agreed scheduling order, but I understand that if you don't, then somebody needs, Mr. Joyner, do you have backup? And I know that's close to your wife's delivery day. Do you have someone to back you up just in case?
I do. Yes, Your Honor.
Ms. Cook, okay. All right. So
Got
that's
3
good.
lawyers on the call. Somebody else step up.
Oh, you have 3. I didn't realize that. I'm sorry. I wasn't sure who's, okay. So somebody can cover this. This isn't a huge deal, but I'd want to make sure that we're not going to interfere with anything for you. So, okay. Anything else we need to chat about, guys?
Not from the plaintiff side, Your Honor.
Not from Mohala's side either, Your Honor.
Hey,
Okay.
Your Honor. Mr. Cliff, tell Raggy I said hello. I haven't seen him.
If
in
I
a
can
while.
ever find him again, I will definitely do that.
Yeah. Okay.
And I'll just commend both sides. I thought the briefing on this is excellent on both sides. I'm gonna, anyway, just very good job, both sides. I don't know who actually did the briefing, Mr. Joyner or Mr. Cook. Did you do the briefing? Ms. Cook, great job.
Thank you,
Yeah.
Judge.
And who did it on the other side?
I was tasked with that.
Okay, so
We're
Great
a
job.
little top heavy, so I have to do that work right now.
yeah. You should have a young lawyer do that next time, hopefully. So, but great job, both sides, and we'll get you a decision within the next 3 to 4 weeks. And if for some reason I don't, please reach out and say, "Hey, Judge, you need to make a ruling on this," and I'll get something. Did you already submit proposed orders?
I filed one, Your Honor, with the court.
I have not yet.
Okay.
I will get you something over.
Yeah, what would be nice is if you each could submit. I know this is going to just COVID. It makes everything more difficult. If you could just in that notebook you're giving me, just give me a proposed order for both sides would be great, as well as the briefing. So that'd be very nice. All right, guys.
Your Honor.
Thank you, guys. The great job, and we will get you a decision soon, and we'll see you on December 6th, possibly.
Thank you,
Thank you, Your
Judge.
Honor.
Thank you.
Congratulations, Mr. Joyner. I hope everything goes okay.
I appreciate it. Thank you.
Thank you.